Meet Mr. Victor, a Shire folk billionaire and investor. He is the proponent and biggest investor for the Utopia project. Utopia located at the heart of the country of Westeros. It is the biggest project in real estate development for the entire 22nd century. Westeros and Middle-earth signed a bilateral treaty for the protection of investors based on the principle of reciprocity. Mr. Victor and Westeros, represented by its Minister for Tourism and Minister for Foreign Affairs, signed an investment contract for the development of Utopia and bilateral treaty with the state of Middle-earth. It is agreed upon that Mr. Victor shall finance the construction and development of the property and shall share with Westeros the profit derived therefrom. The contract, among others, provide for the benefit of tax assumption by the state of Westeros of tax liability of Mr. Victor for the risk he took for the exploration and development of Utopia. However, a year after the construction commenced and when 90% of the project was completed, the Congress of Utopia declared that the tax assumption clause was illegal, as it was an illegal appropriation of public funds. Subsequently, the project was halted and Mr. Victor was ordered to desist from doing any further construction. The project was expropriated by the government of Westeros and the contract was declared void. Due to the annulment of the contract, Mr. Victor suffered irreversible business losses and is at the brink of he lost his biggest project he invested on and lost his hard-earned money for the cost of the development.
I need to claim compensation for the cost of construction of the project which they continuously use.
Sir, with all due respect, there is no dispute resolution clause in the contract we've signed with Westeros. We can file a case against Westeros in their highest court for compensation based on quantum meruit, plus damages because we have to exhaust first all local remedies.
Mr. Victor was hesitant to file a case against Westeros in its domestic court. He knows he is at a disadvantage and he believes that the domestic court of Westeros cannot be sufficiently impartial to settle their disputes. However, since he was also of the belief as per his lawyer's advice that the litigation is the only way, he went through with it. But litigation brought him more problems. He realized he was incurring more losses and wasting time and effort. He became more anxious and depressed and took a toll on his health. He immediately called his trusted legal counsel, Attorney Denise. He realized it was not such a good idea to have litigation in case of dispute, so he needed a well-informed advice.
Attorney Denise, can you discuss the matter about litigation and its effect in our contract?
Sir, Attorney Jane is correct that we have no dispute resolution in our contract. The effect is that, in case of dispute, we have to resort first to exhaustion of local remedies before domestic courts of Westeros in case of dispute. That is the problem, sir, because most investors do not perceive the courts of the host state as sufficiently impartial to settle investment disputes. In addition, domestic courts are bound to apply domestic law, even if that law should fail to protect the investor's rights under international law. Domestic courts other than the host state are not usually available since they will either lack territorial jurisdiction over investment operations taking place in another country or be prevented from exercising jurisdiction by the host state's sovereign immunity. A further factor militating against the use of domestic courts is the often complex nature of investment disputes, necessitating specialized knowledge. So you see, sir, it is more in keeping with our favor to include a dispute resolution clause in our contract. We can do so by reformation, but even without it, we can resort to other means of dispute resolution and avoid litigation.
What do you mean? And is litigation really a disadvantage?
Unfortunately, yes, sir. It is a disadvantage. Here, let me explain to you. Litigation is costly and expensive, inherently uncertain, and time consuming. Litigation itself can be drawn out, and even if you obtain a favorable ruling at the trial court level, that ruling is subject to a lengthy appellate process. Ultimately, sometimes, obtaining resolution can take many years.
So, what do you suggest? What is your plan?
ICSID, sir. We can put that in our contract or enforce it through the bilateral treaty signed by Middle Earth and Westeros. ICSID, or the International Center for Settlement of Disputes, was established in 1966 for legal dispute resolution and conciliation between international investors. ICSID is part of and funded by World Bank and has its main headquarters at Washington, D.C. ICSID solves all those problems we have in litigation. First, the ICSID process is specifically designed to complement the unique characteristics of international investment disputes, maintaining a careful balance between the interests of investors and host states. Second, ICSID has the expertise to provide assistance under its own rules, the UNCITRAL rules and other procedural rules contained in treaties, and is the only institution that can administer cases under all those rules. Third, the ICSID website provides online case registers for all ICSID cases, with a description of each case, up-to-date listings of the steps taken in the case, and links to awards and other case materials. Also, it is cost-effective and enforceable before all state parties to the convention or has bilateral and multilateral treaties for investment disputes. It simply means that, as a non-profit organization, ICSID maintains a cost-effective fee structure. Measures to control costs include a low annual fee for ICSID services and a cap on daily fees of arbitrators and conciliators. And most especially, an award rendered under the ICSID Convention is enforceable as a final judgment of courts in every ICSID member state. Awards rendered in other ICSID-administered cases are enforceable under the New York Convention.
So Attorney Denise started right away and visited the website of ICSID to learn more and to file a request for arbitration. They also reformed their contract with the state of Westeros to include referral for dispute resolution exclusively to ICSID.